Good morning and good afternoon, and wherever everyone is, we're happy to see you today. We've got a great lineup of panels. The very first panel today, let's get started, is managing the GDPR after a data breach. And we have got an all-star cast to talk to you this morning. I hope everyone's going to be interactive with questions, with chat, whatever, because this panel is excited about that. I'm John Stark. I'm going to give you a quick introduction on each panelist, and then I'm going to turn it over to our moderator, who is Jennifer Archie. And she is a partner in the Washington, D.C. office of Latham and Watkins, and a true pioneer both in the U.S. and abroad in the areas of privacy and data breach response. And really one of the first to merge the areas of privacy and IR, incident response, and bring them together in one place, because that's what's really happened, and that's why we have this panel. She's also the editor of the Global Privacy and Security Compliance Law blog, and she's spoken all over the world as an incident response expert and is a true superstar in incident response. We are so happy to have Jennifer. She is right now in Cazenovia, New York. Welcome, Jennifer.
Great to be here.
Excellent. Then we have another Jennifer, Jenny Arlington, who's counsel at Akin Gump, long-standing expertise in data protection, privacy, and cybersecurity matters, true thought leader in the subjects of privacy and incident response. In fact, with her colleague, she was one of the first to write about the recent Court of Justice of the European Union decision, which involved the transfer of data of EU citizens outside of the EU and severely limited the use of standard contractual clauses and invalidated the EU-US privacy shield that so many of us have relied on. There's a lot to deal with on the issue, and I love people who are right out in front and are not afraid to speak about an issue before other people's have. So Jennifer's right now in North London. Welcome, Jenny.
Thank you. Hi, everyone.
Excellent. We've also got Andrew Beckett, who's the managing director and EMEA leader for Kroll's cyber risk practice. And he's enjoyed a lengthy and distinguished career in cyber, which could take the entire 45 minutes to go over. But I'll just briefly tell you, he was with the Government Communications Headquarters, commonly known as GCHQ, in the UK, which provides signals intelligence and information assurance to the UK Armed Forces, and also as a branch head within the Communications Electronic Security Group in the UK, the National Technical Authority for Information Security. Andrew is right now in Cheltenham, England. Welcome, Andrew.
Thank you. Good morning.
Excellent. And then we have Nauwelaerts, a partner at Alston and Burrs and part of their European privacy and data security team. Over 20 years of experience working with global companies on their data protection, privacy, and cybersecurity needs, including the GDPR readiness, data transfer, data security, and breach requirements, and compliance training. Per Wim, data is the new oil, and data analytics is the new refinery. Wim is in Brussels right now. Welcome, Wim.
Thank you, John. Great to be here.
Excellent. And finally, we have Mark Young, a partner at Covington and Burling, who advises clients on data protection, cybersecurity, and intellectual property matters. His particular expertise is all things cyber. Unlike most lawyers in our space, he has a master's in information technology and actually worked as an IT consultant earlier in his career at PwC. What a terrific combination. Mark, you're in London?
That's right, John. That's right. Nice to be here.
Excellent. Welcome, Mark. Well, Jennifer Archie, I'm going to turn it over to you. Can't wait to hear what you have to say today. Thank you.
Oh, well, we're so happy to be here. Thank you so much, John. So just kind of a quick round robin to warm us up. We have a couple of years with GDPR under our belt now, and particularly with needing to report in 72 hours, and when are we going to contact individuals, and how to deal with controllers and processors, and just a few things that, a quick round robin on what are you surprised, not surprised about. Mark, you want to kick us off with that?
Sure, Jennifer. I guess in brief, I'm kind of surprised that there have been so few decisions and fines on breaches. There was a lot of talk in the run-up to GDPR, a lot of focus on it, a lot of concern. But at least over here, we seem to have spent a lot of time working through a backlog of cases, not so many GDPR fines. So that's one thing I'm surprised by.
How about you, Andrew?
Being the supposed technologist on the panel, I guess the thing that still surprises me is that well, everybody's known about GDPR for 4 years now. It's been live for 2. And we are still seeing quite major corporations failing to adopt even basic standards to protect the data. The number of incidents we respond to where they haven't even deployed two-factor authentication on their email is still shocking.
Great. Wim?
Well, Jennifer, I think what surprised me the most is when it comes to notifications that many companies take a no-risk approach and notify almost every data incident that occurs. In their idea, you can be fined if you do not notify, but it doesn't hurt to notify. And that's not entirely true. And I'm sure we'll talk about that more today, but I think more and more data protection authorities are encouraging companies to carefully assess whether or not to notify and whether it's really required, because they're getting too many notifications already that are not reportable. It's creating a lot of unnecessary workload for them. And there's also risk associated with that because, at some point, data protection authorities will feel obliged to investigate your compliance with GDPR overall if you keep on notifying every incident. And I think that's really something that surprised me.
Jenny, your turn. What are you surprised or not surprised about?
Well, I think I'm most surprised that not more people have sought their individual rights following a data security breach. And we have the big data breaches and they have been all over the news, but it's still surprising that people get fatigued and don't really want to engage if their rights have been violated.
Yeah. Well, great. We have so much to try to get through today. So we will dive right in on kind of breach reporting to the authorities, and what are some themes or lessons or observations about in the basic topic of whether and when to report. I'll start with you, Wim, because you flagged that for us in your opening comments. Do you want to draw a little bit more about just sort of what have you learned about whether and when to report?
Yeah, Jennifer, I think maybe another thing just to tie into the notification duty, because there's another theme that I often see come up, which is I hear companies outside Europe say, well, we've experienced a breach and we have some data relating to individuals in the EU, and therefore we should probably notify the European regulators. But it's not because you have data about EU individuals that you automatically are a controller in scope of the GDPR, right? So I think this goes really to the base question of, do we need to notify under the GDPR? And there's guidance from the EDPB on this, and we have more clarity on when the GDPR applies, but I still see quite a lot of confusion on that particular point. And it also ties into directly, who do we notify, right? Because if you're in scope of the GDPR, but not established in the EU, then you may need to notify the supervisory authority of the member state where you have a representative for GDPR purpose. But we also notice that a lot of companies don't even have that in reality. So that's just one item that comes up quite often.
Great, Jenny. How about anything you want to pick up on the whether and when to report?
Yeah, absolutely. So we have the most egregious breaches and we have the big fines of BA, which is 180 million pounds. We have Marriott intention to fine 99 million. We have a big breach, cyber breach by EasyJet, and here the authority in the UK is investigating, we're told. But other than the most significant, as Wim said, very often we see specifically use cases from outside Europe where there is a big cybersecurity breach, and then there is an identified number of people who are located, say, in Portugal, Hungary, the UK, and then some businesses get very anxious about, do they need to notify one of the authorities, all of the authorities? And when you look closer, actually, it may well be that just because you have a Portuguese person, who happens to be on your books, you may not be a data subject under the GDPR, and you may not be offering services and goods under the GDPR. So I think, and the most important thing is, should you really notify, and then take it from there without over notifying.
Mark, I saw you nodding in agreement there. You want to, add anything to Tony's point? Yeah.
I think it's a really good point. I think I see this a lot with global breaches, where there may be people affected or impacted in many jurisdictions inside the EU and outside of the EU. And I think there is often a gut reaction to look at the nationality and assume that you're then going to have to be engaging with regulators in all of these countries. And I think, and I don't know what others on the panel may have views on this, I tend to think this stems from a focus, especially with US multinationals, on US state laws, which do focus on residency. And they do think about, well, where are the people based? Whereas with us, we're thinking, well, who's the organization in charge, and who's the controller, and who do they need to report to? And so frequently, I think at the start of an investigation, it's really important to work out who are the organizations that are the controllers. We may have loads of people impacted inside and outside of the EU, all over Southeast Asia, wherever. But really, are we only dealing with one or two controllers who may be able to report this to one or two regulators? Or are we having to really start to look at the laws of all these other jurisdictions outside of the EU to see if they apply extraterritorially? And you can really avoid wasting a lot of time if you do that bit of work up front at the outset of the investigation while everybody's running around looking at residency.
Yeah, I really like that. I really like that point. I think that that requires a legal analysis. Sometimes that you have to have the right people in the in the room. Stop pausing to sort of do that critical step. Andrew, what about from more of a technical side? Anything that kind of a key theme or observation you want to share about that step of you're in the first 72 hours, and what are you going to tell? Who are you going to tell at the regulator?
I think certainly for the breaches in mid-size and up organisations, it's quite rare that within 72 hours of discovering that a breach has happened, that you're in a position to answer many of the questions that the regulators ask. But you do, or you can be served very well by, in that initial notification, addressing those questions that are going to come. And that's where working with breach counsel really comes into its own. So rather than just saying, no, we've had an incident and we're looking into it, say, we've got a suspected incident. These are the outside experts that we brought in to assist us. This is what we will be determining as soon as we can. What systems were affected, what data was on those systems, what are the number of consumers who are potentially affected, were there special categories of data? And once we found that, we will provide an update. It provides the reassurance to the regulator, but you need to wait until you've confirmed forensically the information before you make a rush to judgment. And we've seen a number of cases over the previous years where companies have rushed, trying to be transparent, but they've rushed their notification or their making the public aware of a breach, not had their facts right, and then had to go back and correct. And that, just flagging up and worrying your public and your consumers unnecessarily is actually more harmful than the extra day or two whilst you confirm forensically what's gone on.
So I think that tees up perfectly to the next question on the 72-hour deadline and how important it's been in practice, and when are you aware for purposes of running that clock? And Wim, do you want to give some insights there on how you think about when an organization should be considered to be sufficiently aware of a breach that the tick-tock clock has started?
Right. Well, Jennifer, in my experience, the DPAs seem to be quite flexible in practice, at least. I mean, I haven't really seen any extreme positions from regulators in that regard. But one thing to bear in mind is just because you're aware of a data incident doesn't mean that you have become aware of a personal data breach as that term is defined in the GDPR, right? So often, you see a situation where the company is investigating the incident, but it isn't immediately clear that there may be affected individuals in the EU. So it usually takes a while before that can be established. And I think the European regulators have acknowledged that and know that that may be a difficulty in practice. Also, I think to the extent that regulators do think there was a late notification and to the extent that that needs to be somehow reflected in a fine, I'm not aware of fines that were aimed at just the late notification, for example. It's usually subsidiary to a larger infringement, such as insufficient data security measures. So again, it is important, but I think in reality or in practice that the DPAs do take into account the practical difficulties that companies are experiencing.
Jenny, anything you want to chime in there?
Yeah, so the obligation to notify the regulators is within 72 hours where feasible. And it's that where feasible which plays a huge part, I think, when organizations are facing a data breach. And as far as the regulator is concerned, if you're seen to be doing everything feasibly possible so that you can notify, that's fine. The question is, how long, if you can't manage within the deadline, how long after that can you keep that goodwill by the regulator? And if we're talking about a day, 2 days, maybe fine. If we're talking about weeks and months, obviously the dynamic changes.
Yeah, great point. So that's talking to the regulator. If we think about contacts with individuals, that is kind of a hot topic, and tees one up potentially for follow on accountability to individuals. The basic idea is that if the communication needs to be made to individuals, it should be made without undue delay, basically as soon as possible, and giving them specific information. So I guess Andrew, what are some observations you'd want to chime in about just sort of the judgments that the harder judgments and closer calls that need to be made about whether and when to contact individuals about a breach event? Yeah.
So, I mean, there's obviously a whole raft of things that come into play quite quickly once you realise you've reached that threshold and you need to notify. A couple of the first ones that I would say is, we have a mantra of think, talk, talk. So, don't rush to it. Common theme, but think about what needs to be communicated and how you're communicating it, and then do that communication. The other thing is around timing. Sometimes, particularly on a big breach, you might be still gathering information on the entire population of consumers to be notified, but you will be up against a deadline set by a regulator or a particular piece of legislation, which means you need to start the notification process before you finalise the population to be notified. And again, that's quite common practice. You can end up with a population that ends up as being tens or hundreds of thousands in cases like Marriott already mentioned, millions. But start that notification and just recognize that it might take several iterations, but make sure you capture everybody, keep accurate records of what you're doing and when you did it, so that you can answer those questions from the regulator about when you started the notification, when they received the notification, and any follow-up actions that are being taken.
For any of the lawyers, do you ever coordinate these kinds of judgments with the regulators directly, maybe in a larger breach or something where they want to engage about it, or are you usually off on your own trying to make your own best judgment about whether and when to communicate with the individuals?
Yeah, I know there the law provides for that the regulator can engage with you on the content, and I've not seen so much of that in practice. The thing I typically see, and I think this can be a big problem, is PR-driven consumer notices that don't actually comply with the requirements, the content that you're meant to actually contain in a report to an individual. And I think that gets very complicated with multi-jurisdictional problems, because you have well-meaning notices going out to consumers that miss a couple of key facts, or just go too early and get it wrong, allocate the blame too early. And then you have to go back over it. And I know that that's been an issue in the US for a while, but we see that quite a lot over here. And it can be particularly problematic with multi-jurisdictional notifications where you've got language issues and concerns as well. And there we have seen confusion come up with regulators asking questions about, more technical questions over what's happened. Keeping control of that as the investigation evolves can be complicated.
Yeah.
And if I could just follow up on that,
Andrew.
Jennifer, one of the other things that you need to consider is actually, those people in your population. If your population is generally elderly, emailing them a notification probably isn't the best approach. They are far more likely to respond to a letter that comes through the mailbox. Similarly, if you're standing up call centres to handle follow-on inquiries from the breached population, an elderly population take on average 2 or 3 times per call than a younger person, just because of the way that they communicate. They have a social nicety to be observed around a call that you tend not to get with the younger generation, who are more used to text speak, and will get through the meat of the conversation around what's happening, and what follow-up steps they're being advised to take very quickly. Makeup of the population can be as important in getting the message across. And regulators are taking a view increasingly on, did you communicate appropriately?
Wim, I know that you have some thoughts about the content of, and whether and when to have a notification to individuals, and the content there in terms of just follow on consequences for having to do that, whether it be any kind of litigation type option, or other kind of claims that come forward. What are some tips and thoughts you have there?
Well, I think in terms of content, there's obviously mandatory language in the GDPR that you have to include, but you probably don't want to make it too legalistic. But I think there's probably 2 things to assume when you reach out to affected individuals. One, the communication will probably be shared. It will possibly end up in the media at some point, right? So don't assume that this will all stay between you and the individual in question. And the other one is, what we're seeing also increasingly is that this type of communication can trigger requests from affected individuals to have access to their data, right? So they're concerned about the breach, and that triggers data access requests, or exercising other data protection rights. So not necessarily just access, but it could be right to deletion or the right to object. And the big question then is, as an organization, are you ready to handle an avalanche of requests in the wake of a breach? And I think that's something that is often underestimated.
Great point. How about Mark? You mentioned earlier that global events, and when you're kind of consulted on, and you've affected individuals inside, outside Europe, within Europe, maybe different considerations as well. What are some changes in the dynamic or the work plan as a result of that? Is the timetable accelerated, or do you try for universal notices, or that's just pointless and you don't try? What are some tips where you have cross-border analysis to do?
Well, I come back to the point I made earlier, which is trying to identify really the jurisdictions that are actually in play from a regulatory point of view. And that does require some upfront work to work out which parts of the organization are in control of the data that has been impacted. And that can be quite challenging to get at the outset. Which companies have engaged with the consumers, which ones have contracted and have a relationship with those consumers, which are deemed to be the data controllers, and therefore which law just applies. Yeah. So there is some upfront legal work there, and then you're talking about, do we have the requisite local expertise, and how are we going to tie that in with the broader forensic investigation, and where is that being conducted from? Because often that will be conducted centrally, most often with a lot of US multinational clients in the US, and then we face the ongoing timing dilemmas, as we've all seen with these investigations. So I think it's key to really identify which organizations and which laws apply as your first step.
Jenny, how about in your experience, anything specific to cross-border practice that you want to add to what Mark's shared?
Yes, absolutely. So I think, to be fair, most companies are trying to do the right thing, and they're just trying to comply with the law. And sometimes, especially in a global breach, where they have a number in the thousands, say, of notification to make, say, for example, in the US, they kind of feel, well, I have 5 or 10 European individuals, what do I do there? It feels weird, one might say, not to notify them as well, because I'm notifying 9,900 in the US. And I would say be careful when you do that type of analysis, because in Europe, if you notify an individual, depending on the language, but it would be almost certainly assumed that you have made an assessment that there is a high risk to that individual. Yeah. And then you're opening up the door of an investigation either by the individual or by the supervising authority. Whereas if an individual has come to your organization on a sporadic basis and you have a really minimal number of European people randomly coming to you, you might not be caught by the GDPR and you might not want to open that door.
No. And can you allow for that in the wording of the notice to say this is a courtesy, this is a, so you're just sort of through careful drafting, making sure you're not sort of acknowledging that they're at high risk of harm? Or?
Yeah, absolutely. Excellent point. You can say, just out of courtesy, this is what I'm doing. But I think that as soon as a notice leaves your organization, you're at the mercy almost of whoever is receiving that notice. And if it's a very friendly customer who says, oh, wow, thank you very much for letting me know, that's great. However, if it's someone who actually wants to cause trouble, that might become not very welcome.
So I'm going to throw this out to anybody. We have a question for the panel. Does the panel foresee, or what's your experience with how cyber insurance is, kind of driving the practice, both in terms of, assisting, our clients with the, expense and direct losses from a breach, or are they taking a hard line that maybe, they're not going to cover because you didn't disclose something about your security in the application? But just, what are you guys seeing? Just kind of a quick round robin, or anybody want to raise their hand that make a point about how you're seeing cyber insurance drive your practice in this area?
Just maybe a very quick reaction to that is, I think it's an excellent consideration. First point to think about is do you have an affirmative obligation to consult your insurer, and how quickly? We've seen a couple of instances in breaches where who was the last person to renew our cyber insurance? Where is it, and how long do we have to tell the insurer before we're out of coverage? So that needs to be baked into the incident response plan.
Yeah.
I think from our experience, there's still less than 50% of breaches we're responding to that the company has a valid insurance policy in place.
Wow.
Some of the costs are very high. We've recently worked on a big breach for a very large organization who had the other problem. They had cyber insurance in place, but the excess on the policy, the deductible, was multiple millions. And so they still ended up paying for the breach themselves because it didn't reach the threshold of the deductible. It's important for any board, any management team to understand the risk that they are trying to insure and make sure that the policy they've selected will deliver that risk mitigation, which may be the cost of an investigation, it may be the cost of notification, it may be legal fees, but you've got to understand the risk and then take the appropriate policy and make sure you're covered, and then review it on a regular basis.
That's interesting, because I'd say speak in 2020, I'd say 80% of my incidents, insurance is a major driver. You know, like they're right in there. Who are you going to hire? Who's going to pay for it? How you run it? How, you know, what you get, whether you're using the panel counsel, whether you've pre-selected. So I feel like, I guess it's coming. So because you have to get the losses up, right? For people to, you know, to stand up and take, you know, and take notice that, you know, it's beneficial. And so I think thank you for
it's certainly far more prevalent now than it was 2-4 years ago. And GDPR and the costs of investigating, the costs of reporting have driven a significant growth in cyber insurance, but it's also driven a lot of different policies. Right. You know, so you're either getting a cyber addendum to a general policy, or specific policies that will cover the first 72 hours of triage, and then you're on your own, or the all-encompassing policy. There are a myriad of policies out there to choose from, which makes it hard for the buying organisation to know that they're getting the right product.
Yeah. So, Wim and Jenny, I want to coming back to data protection, you know, law kind of. What are some interesting controller processor issues that either one of you have seen, you know, whether around notification or really any aspect of managing a data breach in the GDPR?
Sure.
Wim, who wants to go first? Yeah, ladies first. Yeah.
Sure. Well, I don't know what Wim thinks about that, but in general, I think processors, obviously their obligation to notify it's only to the controller, but I think generally the processors don't see it commercially that narrowly, because if well, it depends on what kind of situation you are in a business relationship, but usually people want to keep the good business relationship. And if you have to notify your controller and you're thinking, then my controller will need to notify or need to make an assessment whether to notify the supervisory authority, that becomes more of a collaborative approach and looking at things together, which is interesting. And I think there will be probably more of that to come.
What do you think, Wim?
Yeah, I agree with that. We're also seeing sometimes poor alignment with processors who actually then notify regulators when a breach occurs. You know, you would have a processor that doesn't only notify its customer/controller, but will say, oh, by the way, we have also notified the supervisory authority in our country, or we're planning to do so. So again, it's very important that this is clearly coordinated upfront with the controllers, that this is fleshed out in the data processing agreement, just to avoid that the controller is taken by surprise, really. And I think, Jennifer, in the same vein, there's also often no clear division in tasks in joint controller relationships, and it's kind of a new thing coming up, I guess, since the Wirtschaftsakademie case before the Court of Justice of the EU. There's this tendency among regulators in Europe to re-qualify relationships into joint controller relationships, which is quite interesting. But it also has an impact on breach notification and who notifies on behalf of the joint controllers. And again, I think it's important that there's a clear agreement on that before a breach actually occurs.
Mm-hmm. What about, Mark, some, you know, kind of the special cases around ransomware and, you know, notification, or just sort of managing the, you know, a ransomware incident under GDPR? What are some practice tips you would want to share in that with that kind of an event, and may include, paying money to known criminals and, different aspects.
Yeah, quite a lot in there. I would say, just as a general tip, we've not touched upon this, but we've mentioned the guidance, the EDPB guidance that has some examples of when you should and shouldn't notify. It's in that appendix to the guidance. That can be quite a handy first port of call for some of these instances. But with ransomware in particular, I think you're looking at the nature of the event. Is this an availability breach, and what's the nature of the data? How critical is it? Is this data that is relevant to the delivery of, I don't know, insulin to patients, or is this data that is actually not so critical? And what's the criticality, the sensitivity of this? When it comes to issues around payments, what we've seen there is engagement with at least in the UK, the National Cyber Security Centre and the National Crime Agency can be very helpful when they've provided good steer on how steps to take in those situations. Also with just kind of practical stuff about the acquisition of Bitcoin, with market volatility, that can be challenging at times. So these are all things that companies need to be thinking about. Should they be contemplating actually paying a ransom, the mechanics of it? But that's something that we tend to work with some of our white collar colleagues on as well. I'm sure others have good experience.
So here's a question from the audience that's perfect for the U.S. lawyer to tee up to you guys. So, maybe for whatever reasons in the United States, we were sort of going first on, breach notification and the vendors and just sort of the whole infrastructure and way of doing these things. And so you do have a lot of dominance of U.S. law firms and U.S. vendors, U.S.-based forensic vendors, really having kind of, I don't want to say cornered the market, but significantly being maybe just in charge of what's done and how it's done. And do you feel regulatory pushback or hostility or just sort of awareness of, who's here looking out, for us, or that's the question is, do you feel regulators are sort of fed up with sort of a US based, maybe litigator based, type of approach to, just having the locus of the whole investigation be in the United States? It's your chance to shine, guys. Yeah.
Oh, look, I'll jump in with just a very quick reaction, which is not really with regulators, but one just tip or practice point I'd say is the assumption of the privilege rules in the US, which has become a bit of a norm, might not necessarily apply the same way. You don't know where you're going to get sued, so it makes sense to use a lot of similar approaches to privilege at the outset of investigations. But that's one area of culture clash which other panels on today might cover.
Yep. Let's talk a little bit about the role of experts and the privilege and all of that. Andrew, you're quote unquote the expert. When you get brought in, and what do you think is your role? Like what's figuring it out, defensive strategies. What are some comments about how you can work well to really help a shared client with the legal advisors?
Yeah, so that's actually a broad-ranging question. We are quite often brought in pre-breach to help, as you say, with the defensive strategy, pulling together a defensive narrative that says, look, the board's talked about this regularly in advance. It's set appropriate standards and requirements for the types of data that it holds and what it does with it. The organization as a whole has implemented policies, procedures, practices to protect that data, and they have been regularly audited. Great defensive narrative. When you're brought in post-breach to do the incident response, you've got a different set of drivers. And as Mark said, whilst Europe does have a number of countries where legal privilege isn't recognised, we would always prefer to be instructed and appointed by counsel, and having that external legal specialist helping to understand what's going on, to take control of the investigation, and teeing up communications in conjunction with crisis communications is crucial to getting through this. Industry is used to the fact that breaches happen on a daily basis, but it's how you respond and how well you communicate it that really brings the difference to how the organisation recovers at the end of the day. The impact isn't from the breach itself; it's from how you dealt with it, and we've seen classic examples of organisations over notifying, having to go back and correct themselves and suffering massive share price drops as a result of it, and others with far more serious breaches where the greater volumes of data have gone, but they've handled their press release with their experts on side, maybe law enforcement on side, saying they notified us, we were involved, this is what we found, we quickly notified affected organizations, etc. And the markets sit there and say, yeah, you handled that appropriately, you're a well-managed organization, and there's very little impact on the share price. And indeed, for some, like the breach a few years ago at RSA, their share price actually went up in the immediate hours after they notified of a breach, because the market said that was the right way to do it. It's a well-run organization. We can trust them with the data,
right.
And we can trust them to respond appropriately.
Yeah, great points. Wim, how does overall data, GDPR compliance intersect with data breach, communications, and out in the United States, certainly there's a bit of, if you get into data breach, it's a bit of a 360. It can be, right? Just sort of people having a look and asking a lot of questions, and who's the controller, who's the processor, have you guys sorted this out, correctly? Did you appoint the representative you should have appointed? So what are some comments on, sort of those other parts of the GDPR beyond notification that can come into play by reason of a breach?
Jennifer, I think it's a real possibility. Actually, there was a recent case in my home jurisdiction in Belgium in April 2020 before the Belgian Data Protection Authority, where a telecom provider had notified a personal data breach, and it involved sending emails to a wrong recipient. Now, the DPA had some questions about that breach and was initially a bit annoyed because they felt that the company was not very cooperative in the overall process. And they also had the impression that the company did not sufficiently assess the risk of harm as a result of the breach. So the DPA decided to dig a bit deeper into the company's overall GDPR compliance and discovered that the company's data protection officer was actually wearing 3 different hats. So in addition to being the DPO, that person was also responsible for the compliance, internal audit, and risk management department of the company. And so the DPA said, well, that's way too much. That DPO cannot be in an independent position anymore. There's clearly a conflict of interest created by the company. And ultimately, the authority imposed a fine of 50,000 euros. So, and the fine also only related to this aspect of DPO designation. On the other accounts relating to the breach, there was no fine. So again, I think it's an interesting case that demonstrates the unexpected effects of notifying a breach.
Mm-hmm. Very good. So, breach, we always use the same word, but the root causes of breaches have, can vary widely. And I think the ICO recently reported that, overwhelmingly, disproportionately, the root cause of a lot of breaches was just sort of inadvertent, what we would kind of think of as leaks rather than malicious, attacks. And I wondered if, Mark, you want to just comment on a little bit on the different dynamics where you're addressing a leak versus something where there's been a kind of a known malicious act involved by an outsider.
Yeah, that I think that aligns with what we see in practice. The kind of day-to-day, week-to-week, run-of-the-mill breaches are often mistakes or accidents, human error, employees doing silly things that they shouldn't be doing, lack of training. There's a reason that CISOs worry just as much about their own employees as they do about external hackers, if not more. But of course, it's the headlines are the large, typically external hacks or anything with a nation state element. But actually, I think I don't know the statistics off the top of my head, but I would expect the vast majority of breaches that are reported to be in the first category. I did have a quick look at that ICO report, and one thing that I thought was interesting was just the outcomes. And it seems like the vast majority of outcomes in relation to breaches reported was no action for the controllers, which is just an interesting stat.
Yep. I know, especially if we think back to 3 years ago, 4 years ago,
Right.
As Andrew said, we're really kind of 4 years into this conversation, and all of the linking of the 72 hours and the fining and the 72 hours and the fining, but really there was a rationality underneath the approach that sort of settles in a better place. Well, I see we have about 5 minutes. I think that should give each of you a little pocket. I'll start at the top for me with Andrew on, just sort of going forward, looking ahead to the next, couple of, I don't know, you can pick your time frame, next year or so under GDPR. What have you got your eye on, and where do you, some changes in your practice, really just wide open chance for you to give our audience, just sort of a sense of what you're looking at for the future.
Yeah, thank you.
Go ahead, Andrew. Yeah.
I think from my perspective, I'm still waiting for those fines and rulings on GDPR breaches to start coming through, and the establishment of case law that gives us all a better understanding of what the regulators across Europe are doing with their interpretation and their fines. And I think once that starts to happen, we'll get some clarity on whether things like class actions are going to become a big thing in our future. I personally think they will be. I think we'll see a lot of class action following data breaches, but there's no certainty at the moment. I think we'll also see a growth in or a continued growth in the cyber insurance market once we understand what those risks are. There are still a lot of boards of major companies who are saying, well, what is the risk? I've got these scary headlines from GDPR and 4% of global turnover, but in practice, has that ever happened? Is that a risk that's likely to materialize? And if so, that will shape what I do to address the risk, whether we invest in technology or process procedure internally, whether we mitigate that risk by insuring part of it. But we just seem to be at the edge at the moment, and people aren't committing because we haven't got that established case law, that established body of decisions out of the statutory authorities.
Yeah. 1 minute to close. So that gives 30 seconds. Mark.
Very, very quick. Brexit and parallel investigations with the UK ICO and continental regulators, and the wonderful collaboration between the two that we can all look forward to.
Yeah, Wim?
I think the whistleblowing directive that will be transposed next year into national law, and how that will create an additional dimension allowing individuals to directly notify breaches through an alternative means.
And Jenny, you got 1 second.
Artificial intelligence and how that will play out.
Hi, Bruce.
Hi. Hey, fantastic job, Jennifer. Thank you so much to the whole panel for getting us off to a wonderful start. Really appreciate everybody's time today. So that's our first panel. Our next panel will be beginning at 1:10 p.m. British Standard Time. If you enjoyed this discussion of the GDPR, we have 2 officials from the DPC in Ireland coming up who can really help fill in some of the information that we've just been discussing, and you'll hear it right from senior officials. So I hope you'll join us at 1:10 p.m. to hear from John O'Dwyer and Sandra Skean of the Irish DPC. That's our first panel. Thank you, and we'll see you in about 10 minutes.